I was recently asked to consult in a case where there were very, very serious injuries, and a synopsis of the case is on the home page of this website. What that case involved were injuries that occurred as a result of an auto accident in which the driver, a very young man with a known history of drinking, was entrusted with the keys to a car by a parent. And the first thing to keep in mind in such cases is that the usual rule is that prior accidents or prior behavior cannot come in evidence at a trial of a particular accident. That is, we usually do not concern ourselves with a person's driving record in an auto accident case. The notion is that the driver's conduct on the day in question is what matters, not their driving record. However, there can be an exception to this rule, and it came into play in the case I'm describing. And that involves the doctrine of what is known as negligent entrustment. A parent giving the keys to a young driver who is known to drink and will be at a party with alcohol, for example, the parent can be independently responsible, independently liable. And the courts of Massachusetts have addressed this notion of negligent entrustment. And they will say that prior accidents, if they are permitted to come in evidence, must not be used to determine fault or negligence in the particular accident at hand. And in fact, a judge should instruct a jury along those lines. But if the case involves negligent entrustment, indeed you can bring up a driving record or things that have happened in the past, not just in that particular accident. And a skillful use by a lawyer of the concept of negligent entrustment, and a lawyer who brings an action for that, may well be able to present evidence that would ordinarily not come in. The general rule, however, as I say, is that you cannot introduce a person's driving record when determining if a person acted negligently in a particular circumstance. But that case lent itself to the allegation of negligent entrustment. Now, I do want to say in a separate concept of respondeat superior that an employer can always be held, or should always be held, liable for the acts, the negligence of the employee's driving. And nothing I've said in the first several minutes of this blog detracts from that principle. Rather, I'm talking about something entirely different, where there is no employer-employee relationship, and there is an allegation of that which is known as negligent entrustment. And that allegation, in this particular instance that I refer to in the home page of my website, allowed for the introduction or the prospect of the introduction, because the case settled, of evidence which would have been very favorable to our client. Thank you.